not a lot of people are aware of this, and SARS they do use their rights to enforce compliance.
Yeah.
But there's so much more they actually could do if they wanted to.
Correct.
So there's a bit of leniency in some areas where, for example, to update your status, there is one of the required documents that needs to be updated within 21 business days of your status changing. Otherwise, actually, you can get penalized and face the same sanctions of non-compliance.
Yeah.
So SARS is not implementing that, so they're giving that grace. But to emphasize that the waiting period to understand it, not just out of convenience or maybe a refund, it's a requirement by SARS, statutory requirement, which you can face penalties and sanctions for.
Now, without further ado, I would like to introduce my colleague, the most famous guy when it comes to all things tax, John Paul Fraser.
Thank you very much, Mbali. Always a pleasure to be here with you. I know our last topic was very well received by our listeners. And I think today, when we're talking about the need to knows when immigrating, generally when you say it, obviously it's important, but with tax, even more so. So very much looking forward to the topics we're covering today.
All right. No, 100%. So I think before we delve into, the myths, the misconceptions, we need to break down the basics, which is why knowing your tax status matters. I think a lot of people, well, a handful now, kind of know their tax status, but they don't know necessarily as to why it's important that they need to know. Because this does tie into your obligations as well. So if you're a tax resident, as we know, you are taxed on worldwide. However, if you formally cease your tax residency, then your tax obligations in South Africa are quite limited. So on your side, what would you say how this affects your reporting with SARS?
Well, firstly, I think the most important thing is to understand that reporting to SARS is obligatory, depending on your status.
100%.
Including whether you are non-resident. SA-sourced income, you've got to declare and pay tax on. For those residents, every form of income that you do not declare, and I think you just recently did an article which has been doing very well about under-declaring your income.
100%, yeah.
That obligation doesn't fall away essentially ever. But it does remove a very important, and if I could say, a very onerous part of your reporting if you're a non-tax resident, which is non-SA sourced income, if I could say.
Correct, yeah.
So foreign income, financial immigration, you can file a nil return, for example.
Yes.
GTA a bit different. You declare your foreign income, declare it as non-taxable. But the misconception is that just because SARS, firstly, maybe you think you've formalized your non-residency.
Yeah.
You need that notice of non-tax status letter.
Correct.
Or you have not. Until then you can file a nil return under financial immigration.
100%.
Under DTA, also, you need a non-tax status letter. Only then you can declare your income as non-taxable.
Yeah.
And I'll come back to the fundamental point of law. The burden of proof or onus, if I could say, is always on the taxpayer.
Yes.
To show that they don't need
100%.
to report or show tax liability, if I could say that.
100%.
So bearing in mind, before we even delve into tax residency, etc., is there's always an obligation.
Yes.
You just got to make sure what it is.
Yeah, 100%. And just to build on that, you touched on a very important part, or rather point, is that how does one know that they're non-residents? So by simply just packing your bags and leaving South Africa, that does not make you a non-resident. John Paul did mention that you need an actual document. So there's an actual document the SARS does give you to say now you formally have seized your tax residency. So I do get on a lot of calls with a lot of clients who say, but, I've been abroad for so long, surely SARS should know. Well, unfortunately, that's not the case. So you do have to formally seize your tax residency because that will make sure that you tax correctly. And for those who are or have seized their tax residency, it's also important that they should file. Touching briefly on the article that we did or that I did on under declaring. As a non-resident, very important to note that that does not take away your obligations of having to file. Simply, the way that I put it is that SARS just recognizes you as a non-resident. Therefore, your tax number is still very much active. You still have to file. So you still have obligation on your end, because non-filing can result in penalties and possible sanction,
Correct.
Yeah.
Spot on. And just again, a side comment, very important that I'm picking up in consults and just on the ground is that to be clear, there's a very clear distinction between being non-resident
Correct.
and deregistering for tax.
Yes.
So that is just also for listeners out there to be aware of. Non-residency is not that you are not, how do I say it, registered for tax in SA.
Yeah.
It just determines how you have to file and what your obligations are.
100%. And to bounce off of that, to deregister would mean the actual deactivation of your tax number. So this means on your side, once you followed the formal procedure to deregister with SARS, this would mean now you don't have to file. So that's a very, very important thing to distinguish. I think a lot of people do confuse it. It's not automatic again as well with the deregistration. So you have to formally do a formal process with SARS. So we're going to go into the next misconception. And unfortunately, a lot of our clients get these misconceptions and wrong advice from advisors who are not quite sure as to when do I trigger my non-residency? When can I actually cease my tax residency? There is a play between the 3-year rule. There's also a play waiting 5 years before I can cease my tax residency. What's your comment on that?
So I will be honest, this is a very important question. And I actually did an article on this relating to a specific matter I dealt with, where the client obviously very frustrated that he didn't know the correct advice.
Yeah.
And I mean, obviously our firm is tailored on cross-border and expatriate tax. And not a lot of people understand that it's a very niche and highly specialized area.
100%, yeah.
So for those who have been waiting, not for the wrong reasons because of procrastination, but because of maybe you've been told you need citizenship, for example, or
yes, that's a common
a
one.
permanent residence, or you've been told you must wait 5 years before you can cease your tax residency, or 3 years. There's a lot of years and numbers that come up in these kind of things. And to make it very simple, there's essentially 2 mechanisms that we will cover, or really that we deal with, that determine non-tax residency. The first one being financial immigration, or ceasing to be ordinarily resident, or the double tax agreement. And it's as simple as this. Once you have landed or relocated to your foreign country, there is no limitation on you immediately proceeding with your application to cease tax residency.
Yes.
And why that is so important, and why this specific case really hit me or touched home, was until obviously, as we've said, you formalized your non-tax residency, you are liable for worldwide income. So this gentleman has been paying tax for 5 years as a resident, because he was informed he has to wait 5 years before he can become a non-resident.
Sure.
And for those who do not know, yes, we can backdate your application, but if you want to get a refund on tax that you actually weren't meant to have paid, you're limited to 3 years. So there's 2 years of tax liability that unfortunately you won't be able to recover in terms of a simple objection. There's Section 93 of your Citizen Acts for reduced assessments, but that's a whole nother topic. But yeah, so just to debunk that myth, if I could say it, there's no waiting period at all.
100%. Another one that I'm also seeing in practice is the days requirements, which is commonly misunderstood with the foreign exemption, which is the Section 10102 of the Income Tax Act. Now, this exemption is tailored for those who are still regarded or want to still be regarded as tax residents. So there is a day's requirement that you must meet. However, this does not apply to if your intention is not to come back to South Africa. So no, you don't have to wait 183 days before you can actually start the process of becoming a non-resident. No, and then lastly, the 3-year. I've also come across the 3-year, which is confused with the 3-year lockup rule, which is pertaining to pensions, which we will touch on later bit in our session. But the 3 years is basically not in terms of having to wait 3 years before you can cease tax residency. It's simply just so that for purposes of encashing your retirement annuity, you have to prove that you, one, non-resident, formally cease your tax residency and actually have your letter, and you have been living abroad and considered to be non-resident for 3 consecutive years. So that's just one thing that we want to put across and make sure that people clearly understand, because it's quite a misconception in terms of that.
Definitely.
Any last comments?
No, I think that's very important again, because interestingly, our last comment, not a lot of people are aware of this, and SARS they do use their rights to enforce compliance.
Yeah.
But there's so much more they actually could do if they wanted to.
Correct.
So there's a bit of leniency in some areas where, for example, to update your status, there is one of the required documents that needs to be updated within 21 business days of your status changing. Otherwise, actually, you can get penalized and face the same sanctions of non-compliance.
Yeah.
So SARS is not implementing that, so they're giving that grace, but to emphasize that the waiting period to understand it, not just out of convenience or maybe a refund, it's a requirement by SARS, statutory requirement, which you can face penalties and sanctions for. So.
Yeah, which I do delve into extensively in my article, and hopefully we can have a link below so that you guys can have access to that article. In terms of the process to cease tax residency, so obviously we've done away with the misconceptions. The great thing is that this can actually be corrected. So this would be now embarking on a backdated seizing of your tax residency. So the great thing about this whole process is that if you're unaware and they are seeking ways on how do we correct this, the great thing is that you can actually apply for backdated financial migration of seizing of your tax residency. Now, this can be quite a lengthy process, can be admin intensive, especially when it comes to actually obtaining your passport, that especially like for those who've left long ago, having that initial passport that shows your initial exit date is very, very important. So we can remedy this, but obviously you need to get in touch with people who are experts like myself and John Paul, where we can actually facilitate a backdated financial migration. Now, again, you don't need to have your PR in place, like we've heard. As long as your intention is there, which is very, very important, as well as your passport with an actual initial exit date, that will be able to assist us with applying for this.
Yeah, and I think that's very important. There's many sayings, but you get what's called the head in the sand approach.
Yes.
You get the one I love is don't let the grass grow under your feet. So the longer you wait, the worse it's going to get. So for those who have maybe put it off again, not for the wrong reasons of procrastination, but maybe a bit scared of the consequences.
Yes.
The good news is by following a backdated process, you are actually eliminating or mitigating ongoing non-compliance. Bearing in mind, for those who are abroad, you're probably not getting communications from SARS.
Yes.
Because your cell phone number doesn't work in your country, or you had a tax practitioner in South Africa. And the scariest thing for me is not knowing what's going on my profile.
Yes.
So whatever is currently happening is going to happen either way.
Yeah.
So the best thing you can do is to action a backdated application. Benefit of doing so is it essentially remedies your non-compliance.
Yeah.
Because you don't owe any tax liability on the income you've earned abroad then. So I do want to encourage those who have been putting this off because maybe let's just leave it. Let sleeping dogs lie with SARS. I guarantee you that is not the correct manner to approach this with, if I could say that.
So as mentioned, John Paul, I mean, it's very prudent for those South Africans living and working abroad to make sure that they either, whether you are doing the financial migration or double tax agreement, to make sure it's in place, because there are more and more changes that SARS is implementing, that the country itself, South Africa, especially with foreign pensions for those South Africans living and working abroad. I know you are playing quite a critical role when it comes to these discussions. Maybe if you can just give us some light, not too much, but maybe just give the viewers some insights on the upcoming amendments.
Yeah, so I think very important to note, and if I may, I'll speak directly to high net worth individuals as well as everyone else, but specifically high net worth individuals who the stats show that they are leaving the country and not ceasing tax residency. For those who have not done so, irrespective of what bracket you're earning in, if you have a foreign pension fund, SARS is now, well, legislature and SARS and National Treasury are looking to tax your foreign pension for
Sure.
those South African tax residents.
Yeah.
That applies to foreigners entering the country, triggering, and those who have left but not formally ceased.
Yes.
And with this being a very big focal point, I highly recommend, and it's meant to come in, if approved, on the 1st of March next year, 2026.
Yeah.
We have given comments to Parliament and made oral submissions last week. But in terms of that, quite simply, the fact of the matter is as simple as this. SARS is not hitting their collection targets. South Africa as a country is at their capacity for tax.
Yes.
So the simple logic is that SARS is going to continue to expand the net for which they can tax, which means offshore, further and further and more
Correct.
intrusive.
Correct.
So I really encourage everyone who has left and you don't want to implicate your retirement funds that are offshore in your taxable income from SARS, even if you've been out the country, to really, at this stage, cease your tax residency if you have not done so.
Yeah, and I think it's quite interesting how the coin has changed. Previously, prior to 2021, we saw a lot of South Africans leaving for the purpose of actually being able to remit of their retirement annuities. So now it's even more affirmed that you should cease your tax residency, not only for the purpose of being able to remit what's still in South Africa, but also making sure that you protect whatever it's still you've obtained or acquired abroad. A lot of people don't take into mind the assets that they've acquired. They think, how will SARS know? Which also comes into or brings into conversation the third-party reporting. Maybe can you just expand on the importance of making sure that you're compliant, because countries do,
Correct.
liaise. Yeah.
So firstly, financial institutions in South Africa are obligated to annually report to SARS. So SARS knows exactly what's going into your account and going out.
Yes.
Previously, I've done work for SARS, and they know exactly where you traveled to, what flight you were on, and what time you landed. And I'm not exaggerating. But to add on to that, what currently is also ongoing, not just locally in South Africa, but across the world, they are moving towards what's called automatic exchange of information.
Yes.
Up until this point, it's been almost manual intervention. I mean, a beautiful case is the Oppenheimer case from the UK, where the UK HMRC and South Africa SARS to deal with who's got the taxing rights. And,
Yes.
but you have this here, own this there. But what's going to be implemented and is currently underway as we speak is that countries are automatically going to be automated sharing information. So wherever you are, quite frankly, SARS is going to be getting all the information they have on you.
Yeah, I mean, we are seeing a spiral in AI. I know with the US, they already have AI in terms of their taxes and how they do their taxes. So that will follow 100% in terms of South Africa tax. So it's very important to be mindful that taking these precautions earlier is better than actually waiting for later. So any closing comments?
Well, I think I hope we dispelled some old wives' tales, if I could call it that, some myths. I know it's very important that, again, especially with tax, that you know what's going on. Tax can be complex, but I would encourage everyone to make it as simple as possible by simply reaching out to an expert so they get help.
Yeah.
It doesn't help delaying things. It only actually makes things worse. So I would like to maybe ask some of the audience, just if there's any other topics they would like to hear a bit more, please do drop us a comment. I would love to cover those as well. But I think these are very good focal points, and I hope it's been informative. That's me.
Thank you. Just to emphasize, it's very, very important to get someone who's very skilled in this area. It can get very tricky and complex. I mean, in practice, we also do see tax practitioners reaching out to us because this is something that they don't specialize in. So don't take it for granted. Don't think it's just a minute thing. It can lead to something even greater. But yeah, that's it from my side.
Thank you, Mbali. It was a pleasure.
Thank you, John Paul.